Hello, everybody, and welcome to our first webinar of 2021. We hope that I hope that everybody had a good break over the Christmas period. No doubt you're now well back into the swing of things. Thank you for taking the time for joining us today for our webinar. Shortly, I'll be introducing Paul McEnroth, who's going to be speaking during the webinar today. However, before I do so, just a little bit of housekeeping issues for you, and particularly if you haven't used the Webinar Jam system before. On the right of your screen, you should see a couple of buttons for choices, one of which is Files. If you click on the File Download button, you will be able to download the slides from today. So during the presentation, if you want to download the slides, just click on that File button and you'll be able to download them. If you don't get the chance to do that during the presentation or something goes wrong, we will be sending out feedback emails at the end of the presentation, which will also have the slideshow attached. If you would like to ask questions during the presentation or after the presentation, and you are more than welcome to do so, what my role is here today, apart from saying hello, is to moderate those questions and ask them of Paul during an appropriate time in the presentation. So you'll also see a chat button, which I see that Shane has already found. Good morning to you too, Shane, and Happy New Year. Fire in your question via the chat button and we'll ask Paul. And as I said, either during the presentation or after, it doesn't matter. But we will be staying on the line for a little bit afterwards if you've got questions at the end as well. Of course, just a reminder that this is recorded, and aside from being available for you to watch later on, if you want to watch Paul speak again, which no doubt you do, it will be put up on our website. So obviously we'd like it if you didn't, I'll moderate anyway, but no client-specific details in those questions would be appreciated. So in terms of the presentation, today, as I said, Paul McEnroth's going to be presenting the webinar today. Paul is a principal of Cleary Hall Solicitors and based in our Brisbane office behind the bamboo curtain, which I understand is lifting soon, or it's banana curtain, isn't it, Paul?
Yeah, that's right.
Paul does a lot of work in this area in terms of governance agreements or shareholders agreements, dealing with private business and family business, and has a lot of experience in the area. And I know it's an area that Paul enjoys working in, along with the other areas that he works in. If you've got any questions for Paul during the presentation, as I said, feel free to fire them in via the chat function. If your question is, what's Paul's favourite after-dinner drink? I believe it's Pedro Jimenez. So feel free to send bottles of that in as well. Anyway, I'll sign off and I'll be rejoining you at the end of the presentation. Fire away, Paul.
Well, thank you, Adrian, and welcome back, everyone. This is only my third day back at work, albeit that it's nearly the end of January. I took a little bit more of an extended break, so I feel ready and raring to go. So we're going to talk about shareholders' disputes and shareholders' agreements today, because unfortunately they often go hand in hand. Lots of times people come to us wanting a shareholders agreement because they've either heard about a dispute or they've had a previous dispute with the previous owner. And oftentimes it's unfortunately those horrible stories that you hear where shareholders are in dispute that lead people to think about, well, maybe I need to have some sort of agreement. So our agenda for today, we're going to look at some of the common types of shareholder disputes and where the source of shareholder rights come from. There's a range of them. The one we're going to talk about in a bit more detail today is in the Corporations Act, dealing with oppression of minority shareholders. We're going to look at some recent cases and give you some explanations of, I guess, the types of disputes that have been through the courts and the outcomes, to give you a bit of insight as to how difficult it can be to be successful in a minority shareholder oppression suit, and also, I guess, some areas where we could or should have covered in a shareholders agreement before we get to a dispute. And then we're going to go into shareholders agreements and what they should cover. So the source of shareholder disputes probably should be at the top, is money. Oftentimes money is the driver of dispute amongst various shareholders. And those disputes often drive management deadlocks. So where people just cannot agree on the decisions, or for whatever reason don't want to agree on a particular decision. Dividend disputes is obviously, again, a money dispute. And there's been a number of cases where a majority shareholder who may be the sole director has an exorbitant salary and doesn't want to pay out any dividends to the minority shareholder, notwithstanding they might have had earlier agreements about that. An uncooperative partner. You might have a company with equal directors, and one of them is just uncooperative because they may have an underlying dispute, or they may just be generally uncooperative. And that's usually a source of some sort of dispute. And obviously an oppressive majority owner. And the courts are unfortunately littered with cases involving oppressive majority owners who may want to, for a number of reasons, force out a minority shareholder, or compete against to drive that person out or drive down the price at which they might buy out that minority shareholder. So we're going to look at, I guess, actions that might be taken in those circumstances. So what are the source of shareholder rights? Ultimately, the first step a lawyer would usually look at is, well, do you have an agreement? Have you got a shareholders agreement amongst you that would give you some recourse to take action against an oppressive majority, for example? Is there a clause in there about what your shares might be valued at if you're looking at selling? Unfortunately, shareholders agreements are still not a blanket across companies. And the usual step then is to look at the constitution of the company. Now, the constitution is not a be-all and end-all. It's often a source of rules for the company to follow, and generally doesn't cover aspects that cover, I guess, the relationship between the shareholders themselves. It is generally a source of rules for the directors to follow. There will be some aspects about rights that the shareholders have in that company, but in most circumstances, the Constitution doesn't do enough to cover or to protect shareholder rights. The corporations law is another source of shareholders' rights, and we're going to talk specifically, as I said, about oppression suits. But there are other areas in the corporations law that do help in that regard. There may be employment contracts for minority shareholders and other types of contracts that they may have entered into that could give a shareholder, maybe not in the context of their shareholding, but some sort of rights against the company or a director who may be, I guess, either acting unfairly or not doing what they should be. So we're going to look, this table here is about looking at whether the Constitution does enough to deal with some of those risk areas or the causes of conflict. So in terms of deadlocks, it's generally not covered. In fact, most constitutions will say that a chairman of a meeting won't have a deciding vote. If most companies are governed by majority rule of the directors, unless it's obviously a decision for shareholders to make, in which case it would be majority rule again. And in cases of deadlock, there is generally no mechanism to break that deadlock, which generally means the decision doesn't get made. And in some circumstances, that company might grind to a halt, certainly in relation to particular decisions. Dividend payments, it grants the power generally to the company in general meeting or the directors or both But again, there's no requirement to pay dividends. There's no agreement amongst the shareholders that dividends will be paid, provided certain thresholds are met. All it does is it grants power. And again, if we go back to our deadlock situation, if nothing is agreed, then nothing happens. Uncooperative partners and what may happen in those circumstances are not covered by the Constitution. Oppressive majority, again, not covered. In fact, constitutions are generally governed by majority rule, which may in fact reinforce those circumstances. And money disputes, for example, that high salary versus dividends aspect is not covered in a constitution. Conflicts of interest are generally covered in a constitution, but all that generally is required is for you to identify that there may be a conflict of interest, and potentially you may have to, as a director, put yourself outside the decision-making on that point, but that's not always a given, particularly if the majority shareholder was the sole director of the company. And oftentimes it doesn't extend to what's an appropriate salary for that director. I guess the point of this slide is to say that the Constitution generally doesn't cover those conflict areas that we've identified. So some of the, corporations law aspects that can help. All directors have what's known as directors' duties to the company and to the shareholders, and obviously those oppressive conduct situations, and they're outlined in various parts of the Corporations Act. So when we talk about directors' duties, there are a number of them on the screen there, and they're outlined in the sections there. The first being that you must take show care and due diligence in your duties as a director. That will generally be the case even if you were a director who was oppressing a minority shareholder. Oftentimes you can show your actions are good enough to show care and diligence for the company. You must act in good faith when performing your duty as a director. You must not use your position as a director to benefit yourself personally, and your use of information, you mustn't use, say, confidential information to enhance your own circumstances. When the conduct is so reckless or intentional, and it is an intentional breach of those first 4 bullet points, it can be a criminal offence. Now, the use of that is not widely used, and it will be a fairly high bar to get over to show that, say, for example, your breach of good faith to the company is so egregious that it would be a criminal offence. But there is that remedies there. Directors' duties, while they're important and they need to be there, they're often not ones that are litigated through the courts in significant detail. The ones that are litigated through the court is oppression, and there's many cases, and they come out very regularly. They're often quick cases through the court because the conduct is happening now, and a decision needs to be made by the courts as to whether or not that conduct should be stopped. So often these cases will get to court fairly quickly in order to, I guess, as I said, stop that conduct from continuing. But the grounds that need to be shown by the minority shareholder are that either the conduct of the company's affairs, an actual or proposed act or omission by the company, or a resolution of members or of a class of members of the company, either needs to be contrary to their members' interests as a whole, or oppressive or unfairly prejudicial to one or more members in that capacity, or in another capacity, perhaps as a director. So what you'll take from that slide is that the use of the word, I'll take you back here, the court may make an order, means that it's actually discretionary as to whether the court imposes an order to stop a conduct from occurring, for example. So even though you may be able to show that conduct is oppressive, an order may not be made in your favour. And that may be for a number of reasons. And one of the cases we're going to talk about later has that exact scenario. And there's no limitation on when or how the oppressive conduct might come about. So it can be conduct in the future. It may be that the director has decided to pay a dividend, for example, on a new class of share issued only to that director. It may be even that the issue of the share was done without following all the right rules. That conduct may occur in the future, and it may be required to be stopped, and that's why there's no, as I said, there's no limitation on when it occurs. And the conduct can be oppressive to all of the members, or one, or just a select group of members, as you'll see in a few of the examples. So if you can go to the court and show that the conduct of the majority shareholders or the directors of the company, which will generally be the same in these circumstances, is oppressive, what can the court do? The court in those circumstances has very wide and broad powers to stop the conduct. Most of the cases that come forward fit into one of two categories, probably three. One, to stop an action from occurring in the future. Two, to force a sale of the shares to the majority. So the minority wants to be bought out by the majority, and they want the court to force the majority to buy. Or three, they want to wind up the company. And in most circumstances, that is something the court is asked to do sometimes as a first step, but often as a final step if one of those other orders can't be made. Now, there are other orders the court can make. The cases that are reported, these are less likely to be asked for, but they can include modifying the constitution of the company, regulating the conduct of the affairs in the future, and that may be, say, stopping the dividend payment in my earlier example, company buying back shares. It may want the company to act in a current proceeding. There are other mechanisms called derivative actions, in which case a shareholder may ask the court to sue someone or defend an action and stand in the company's shoes, but this is actually forcing the company itself to be the one who acts in those proceedings. They may want to appoint a receiver and manager to any or all of the company's assets. They may want to restrain conduct from occurring or compel an act to occur. So you can see there that the scope of what a court can do and can be asked to do is quite large. But as I said, the top three are really, winding up a company, ordering sale or purchase of a share, or stopping an action from occurring. So the tests that are applied by the court in these circumstances, it must be something that stops the oppression. So if the oppression is stopped all by itself, the court is not going to intervene. So there must be a continuing oppression. For example, if the directors in our circumstance where they said they're going to issue a share, if they rescinded that notice to shareholders, well, the oppression, that oppression has ceased. Now, there may be other conduct that is oppressive and continuing, but if that were the only oppression, then a court's not going to step in and say there's oppressive conduct because it's not continuing. What the test the court looks for is this loose term, commercial unfairness. And in lots of circumstances in the law, we look at something from the objective eyes of a bystander. And this quote is taken from a case that's often cited as being one of the tests of commercial unfairness, and that is, objectively, in the eyes of a commercial bystander, there has been unfairness, namely conduct that is so unfair that reasonable directors who consider the matter would not have thought the decision fair. So that lawyers are quite used to those sorts of tests where you have a reasonable bystander looking on and saying, well, objectively, would I have done the same thing, or would I consider that to be the right thing to do? So in a oppression suit, that is what we need to satisfy the court of in order to be successful on a suit for oppression. So examples of oppressive conduct, and these are all taken from various cases in this area, excluding directors or shareholders from management of the company. Now, they're very broad statements, and they're not going to apply to all circumstances. It may be that it may be legitimate to exclude particular shareholders from management of the company. But these are, taken from cases that have certain sets of facts. But they, I guess, as a broad statement, if your clients come to you and say, well, this is the conduct, I'm being excluded from management of the company, it may be that is oppressive conduct. It will be determined on the facts of those circumstances. So probably put that caveat on this slide, that although it's up on the screen, merely doing that is not necessarily going to be oppressive conduct. It will depend on the circumstances. Other examples include having mini board meetings before a real board meeting in circumstances where decisions are made at the mini board meeting and they're a fait accompli at the next level. Lawful termination of an employed director's contract may be oppressive. Giving excessive salaries to directors when not all shareholders are directors and dividends don't come out of the company. Blocking sale of shares. If someone wants to sell their shares to a third party or an employee in the business, for example, just blocking those for the sake of being oppressive will be oppressive conduct. Denying shareholders information they're entitled to. Using company money to defend an oppression suit is oppressive conduct in itself. Improperly issuing shares in order to outvote other shareholders are all examples of oppressive conduct that have been through the courts. So we're going to talk about this case, which is Dr. Leo Shanahan versus Jatis. That may not be the way to say it, but that's how I say it. We're talking about this case because it really highlights various different aspects that happen in lots of companies that we deal with. And in that case, there were two groups of shareholders, one being a majority shareholder group holding 57% and the minority holding 43%. They operated an eye hospital in Canberra, and it was quite a profitable business. All seemingly went along fine until the minority group retired and basically sat on the sidelines playing golf and earned passive income from the hospital, which was directly from the efforts of the majority. Now, there was no effective agreement in place in the early days. They did come to an agreement in the middle of the dispute, but there was no agreement on, say, a shareholders agreement where they agree that if you leave the business and stop working, your shares are offered for sale to the others. So that minority group were within their rights to sit on the sidelines, do nothing, and earn dividend payments when they were paid from the company. And that's what they wanted to do. They wanted to continue to be minority shareholders earning dividend income in retirement. The majority wanted a succession plan for their shares. They wanted to effectively buy the shares themselves or bring in other doctors who would buy shares and be workers in the business. Now, once the majority couldn't buy the shares of the minority, they started a competing hospital, which caused financial stress on the original business. They appointed friendly, supposedly independent directors, and that became particularly relevant later on because they frustrated attempts to hire new doctors in order to keep the hospital profitable. And those independent directors were the deciding votes in appointing voluntary administrators, despite the company not being insolvent. Now, it turns out that from an early stage after the minority left, there were talks of liquidating the company when it became apparent that they weren't going to sell their shares to the majority. And that became relevant, obviously, later when they said, well, one, it's not insolvent, and two, you've been talking about this since the early days in order to effectively force out those minority shareholders. So prior to the hearing, the minority actually sold their shares to the majority. They came to an agreement, probably after lots of war of words between lawyers as to what should or shouldn't happen with those shares, but they actually sold their shares to the majority. But the minority believed that their shares were undervalued, that the majority had taken steps in order to reduce the value and generally just didn't pay what they were worth. Now, the New South Wales Supreme Court said that the conduct of the directors and majority shareholders was oppressive. But when they went through and determined what the value of the shares was, they said that, the shares were not undervalued when you sold, and therefore we're not going to grant an order in your favour. Effectively, they were seeking more money based on the purchase of their shares. So in this case, the conduct by the majority was oppressive, but no order was made. So what does that mean for costs? There's a rule in cost circles called costs follow the event. It took me a long time to work out what that meant, but basically it means if you win, you get your costs, not all of them, paid by the loser. So in this case, notwithstanding there was oppressive conduct, no order was granted, and therefore the minority were ordered to pay the costs of the majority. Looking at the case, there were QCs on both sides, plus junior counsel, plus very significant top-tier law firms, plus costs were ordered. So a very expensive process for the minority, and they ended up getting no more than what they already had. So I guess that's one example of many that have gone through the courts that show you probably the value if they had a shareholders agreement in place before the minority left. A lot of this would have been done away with because there would have been a process to follow, and it would have at least they would have had that conversation as to what happens, what's that succession plan when someone retires. So why do we put in place a shareholders agreement? Well, the first and probably primary reason is to avoid, to the extent possible, any conflict. Now, conflict can't always be done away with. That's an impossibility. But It will reduce situations like in Dr. Shanahan's case, because there is a clear path forward that everyone has agreed to. We might not agree on every step. We may not agree on valuation, but at least there are steps that we've agreed to. And if that means that the valuation is done by an independent valuer and everyone accepts that valuation, whether they like it or not, well, that is the path forward. It also provides for an orderly conduct of the business. Again, that succession planning. So if you leave the business or retire, what happens to your interest in the company? And effectively, it's a commercial divorce agreement, or commercial prenup is probably the better way to describe it. It tells us what happens in a commercial sense when we either want to go our separate ways through retirement, or we don't get along anymore, or what happens if there's a forced exit. So again, the issues to consider, and we would cover all of these aspects in our shareholders agreement. The orderly management of the business, and what does that mean, and what are the parts that are involved? How we might value the shares or the company as a whole. Trigger events for the exit of a particular shareholder. Buy-sell agreements, and how we might fund those buy-sell agreements, and dispute resolution. So we'll talk about these separately. So orderly management of the company. Some of the areas that we talk about are board appointments. What is a threshold for appointments in a company that might have a larger number of shareholders, or a distinct difference between the voting power? So, for example, a company that has 95% to one shareholder and 5% to two or three others. What are the thresholds for appointment as a director? What voting power is there in those circumstances, and how we might, I guess, replace directors of the company. Decision making. What are the major decisions of the company? And in those circumstances, are they shareholder decisions or are they director decisions? And oftentimes we will have a list of major decisions involved. Say, for example, the sale of the entire business. Well, in some circumstances that should be a director decision, but in most cases, the shareholders will want to have the power to decide that. And we might have our view of what those major decisions are, but they will be directed largely by you and your clients as to what they consider are the major decisions. Some other ones may be thresholds for borrowing, thresholds where directors need to seek consent in terms of spending over certain amounts of money, and that may involve shareholder votes. Other areas, dividends, what the dividend policy is, and oftentimes a shareholders agreement won't have those, I guess, set in stone. It may be that the dividend policy is, I guess, updated by resolution of the company in general meeting, or it may be the directors. But at least we know what that mechanism is, and we have a set, I guess, process to follow in order to have that dividend policy. Other companies will have a set policy where the might be the EBIT is over a certain level, then dividends will flow. You find those we found them recently where we acted for private businesses that were being bought out by listed companies, and those listed companies, although they weren't completely widely held, they because they had, I guess, majority interests of private equity, they had set dividend formulas in their shareholders agreement. Salaries, Aren't often covered in a shareholders agreement, but can be, and in certain family constitutions we've done, we certainly set out what salaries in the business might be and how we deal with loans into the business by various shareholders. Another area we talk about is the valuation of shares or the company. So what's the methodology that we use? And we've got 3 there on the board. There can be many others, and it will depend on the circumstances of the company. It can be an agreed amount reviewed annually. So this is probably more relevant where you might have 2 equal shareholders, and they might say, to each other, well, this is what we think the value is, and we resolve that every year. That may grow or it may shrink, depending on how they've gone, but they agree on that figure annually, so that if a trigger event occurs, one of them passes away, for example, well, that's the agreed amount of what they say the business is worth. In larger shareholder groups, that's probably not as relevant. So in those circumstances, there may be a formula that's used. It may be a multiplier of future maintainable earnings, for example, or they may appoint an independent valuer in that particular industry. And again, there is a dispute mechanism if someone disputes a particular valuation. This is probably one of, the more important areas is what are the trigger events for an involuntary exit. Now, death, unfortunately, is an involuntary exit from a company or TPD. And what happens in those circumstances? What happens if one of the parties becomes insolvent? If they're individual shareholders, if they become bankrupt, or a corporate, they go into liquidation. In those circumstances, the continuing shareholders probably don't want to have a trustee in bankruptcy be their partner, so to speak. So in those circumstances, it would be a trigger event for that party's exit from the business. Now, obviously, you still have to pay market value for the shares, but in those circumstances, if you can fund that, then you can exit that party and not have to have the complicating factor of a trustee in bankruptcy being a shareholder. What if a director gets dismissed, say for a fraud or something similar? Well, that would cause an involuntary exit of that party as a shareholder. If there's a change of trustee without consent is another area where we have as a trigger event. And if they fail to be involved in the business for a particular period of time. So that would have helped in the circumstance of Dr. Shanahan, where the group of minority shareholders were no longer, or they retired. If they weren't involved in the business, then they would offer their shares for sale, and they wouldn't have, I guess, a say about it. They would again receive market value for their shares, but that's pretty much what the majority wanted in that case.
Excuse me, Paul.
Yes, Adrian.
Just a question from Eleanor. How important is a shareholders agreement if the shareholders are spouses holding equal shares, or if there's a single shareholder?
So I'll deal with, I guess, the single shareholder first. Now, single shareholder, look, they probably don't need a shareholders agreement because most of the aspects they're dealing with themselves in most circumstances. If they had a board that was more than themselves, and they wanted to control what powers the shareholders had to control the board in a way, then a shareholders agreement in that circumstance would be worthwhile. Where we often say to clients who are sole shareholders that they should get a shareholders agreement is prior to them bringing in another shareholder. If they're going to bring in an employee, then they should have a shareholders agreement in which they outline to that new shareholder, these are the rules. And they really, I guess, need to dictate to a large degree what those rules are if that person wants to come in. As between husband and wife, sole shareholders, it's often difficult because you're often saying to people, well, think about the fact that you're going to get divorced at some point down the road. No one likes to think of those things happening to them, but when if that comes to fruition, they're going to be in serious dispute. They would have probably their dispute would probably be more acrimonious than most commercial disputes. They're going to have obviously the family side, but also splitting up a company. Now, it may provide them some solace that they've got some set of rules to keep the company going forward. It's probably going to be dealt with in the family court proceedings regardless. I probably wouldn't recommend it, but look, they could put it in place. At the end of the day, if you tried to sell a family, I guess a shareholders agreement to most mum and dad shareholders, then they're most likely going to say this is not for us. It's not really relevant.
Thanks, Paul. And before you restart, just another question from Roland. Just seeking some clarity. When you're talking on the earlier slide about change of trustee, he just wants to clarify the trustee of what?
So if one of the shareholders is a trustee of a family trust, for example, what we're trying to do in those circumstances, if there's a change of trustee, you might deal with Paul McEnrother's trustee for the XYZ trust. One way in which you can control who the shareholders are is obviously binding the trustee to the agreement, and if that trustee ever changes, you want consent from the other parties that this new trustee is going to come into the company, because they're the ones who are going to go to shareholders meetings. And you don't want a circumstance where a trust could change its trustee, could change its beneficiaries for it even, and suddenly you've got a shareholder who is not the person that you thought was a shareholder originally. So what we say is that if any of the shares are held by a trust, the trustee is the one that signs the document. And they can't change trustee of that trust without the consent of their fellow shareholders. Otherwise, that would be a trigger event for the sale of those shares.
Thanks, Paul. One further one from Eleanor again. Is the shareholder agreement also crucial? And I'll just say I'll quickly answer this since I've had time to consider the question. Is the shareholder agreement also crucial in the case of trustee companies? I'm assuming Eleanor means that the operating entity is the company acting as trustee. If it's a discretionary trust, then no. If it's something like a unit trust where you've got different ownership from different parties, then you would have an agreement. You'd likely call it a unit holders agreement or governance agreement. I'll throw back to you, Paul. There's one question which I'll read and come back to you after you keep talking.
Thanks. So another clause or set of clauses that we have in a shareholders agreement is a tag along and drag along clause. Basically, they operate in slightly different ways, but they're really anticipating a sale of the shares or the business. So if there's an offer to buy, and that offer is made to a majority shareholder, and if I own 60% of the company, for example, and someone offered to buy my 60%, what I have to do in those circumstances is I have to get the purchaser to offer the same deal to the minority, so that those minority shareholders, if they want to, they can tag along on that sale. So I can't offer my shares for sale. My minority shareholders they'd love to get out too, but I haven't arranged for it. So in that way, those minority shareholders can tag along if they want to. They don't have to. But If they want to tag along and the purchaser says, well, I don't want 100%, I only want 60, then the sale doesn't happen. So it's kind of a protection for both sides, both the majority and also the minority in those circumstances. A drag along is something is a bit different. And that's where a buyer comes along and says, I want to buy 100% of the shares. And I own 60% and the minority doesn't want to sell. They say, well, no, this company's profitable for us. We don't want to sell. Well, if the purchaser wants to buy 100%, the majority can drag along the minority and sell the company. So again, that probably the 60-40 split is not the greatest example. Often those thresholds might change, but think about in a circumstance where you get 95% of the company shareholders all agree to sell the business, and you've got one shareholder who owns 5% of the company, and they're the stickler in the mud. The purchaser only wants to buy 100%. So in those circumstances, a drag along says to that 5% shareholder, the business or the shares are being sold.
Hello again, Paul. Have you got a minute?
Yes.
So there's two questions. One's from Mike, which is fairly long. So what I'll do with your question, Mike, is we'll do it at the end after the presentation because there's a bit to discuss on it. So I just don't want to get too far off track. Another one from Brett. Paul, does the company entering into an agreement bind future directors to the agreement?
Yes, it does. Well, it binds the company. So essentially, the directors, by extension, are bound because the company is bound. If the company doesn't abide by that contract, it's merely a breach of contract by the company. Now, that's something that those directors, if they decided to breach that contract, then the company would be liable and damages would be paid by the company. Or perhaps the future directors might be subject to an oppression suit like we talked about, saying, well, this is the agreement. The company is now avoiding its obligations under the contract and it's being done by the majority shareholders or the directors.
Thanks, Paul. As I said, for Mike, your question will come back at the end of the presentation. So back to you, Paul.
Thanks for that, Mike. I'm now worried about those questions for the last few slides. So looking at buy-sell arrangements, now there are two different types. One is between shareholders and then one is on one of those, involuntary exits like on death or TPD. So between shareholders, there are a couple of different mechanisms in a shareholders agreement. One is, an offer notice where a shareholder says, I want to get out, and they offer their shares for sale to the rest of the shareholders. The remaining shareholders who get made an offer to purchase have the right to acquire a percentage of those shares, a proportionate amount, according to, the shareholdings that they have. So, for example, if we had 4 shareholders and one wanted to sell their shares, the other 3 would get a third of the shares offered to them. So a third of that 4th shareholder's shares offered to them. Now, if only 2 of them wanted to buy, then they could buy, and they could buy all or half each of that 4th shareholder's shares. So I hope I didn't confuse you there, but there is a mechanism by which that process unfolds. And that process of acceptance or offering and acceptance is set out in the agreement, and it includes those things like price, terms of payment, who gets offered to buy the shares. The other mechanism is where a shareholder wants to buy out another shareholder's shares, so they can offer to purchase that person's shares, and the terms are set in that offer. If we're talking about one of those involuntary exits that we talked about before, if that trigger event occurs, so death, for example, that trigger event offers that person shares for sale. Again, it's offered to the other shareholders in proportion to their shareholdings. The shares are valued according to the valuation clause. There are set terms in the shareholders agreement as to timing for payment, how I guess if one of the persons who are offered shares don't want to take it up, but other shareholders do, how does that work? So all of the terms of the sale are listed in the shareholders agreement. Funding on a trigger event, such as death or TPD, is one of the questions that comes up probably most, and generally it is done by use of insurance. So insurance on the life of the shareholder, and that shareholder, I guess, will take out that insurance. Their estate would be the ultimate owner of the insurance policy, and it would have an impact on the sale price of their shares. So if I received a payout from my insurance policy and that amount was more than the market value of my shares, then the shares get transferred without any further payment being required. If it's the other side, so if I receive a payout of $1 million, for example, and my shares are worth $1.2 million, then the other shareholders who are buying my shares need to come up with the extra $200,000. So that is often the case as to how, I guess, these types of buyouts are funded, and the agreement takes that into account and deals with how, I guess, listing the policies and other information regarding it. And a good portion of the agreement is deals with dispute resolution. So court is always a last option, and I guess the agreement has various different layers, both for general disputes and also to specific disputes about specific parts of the agreement. Say, for example, a valuation clause, that may be a specific dispute, and each of them have slightly different mechanisms. But the general thrust of both lots of dispute resolution clauses is that court it is the last option unless urgent relief is required to stop something from happening. I guess, oftentimes these matters will get referred to a third independent party, maybe a party appointed jointly by both sides of the argument, and that person generally acts not as an arbitrator or a court, like in a court sense, but they will come in and they will make a decision as to what the outcome should be, and that will bind both sides to the dispute. Now, obviously, court is never going to be off the table because everyone has the ability to take a dispute to court. But when you have a set framework in place and you go outside that framework, a court will look more harshly upon you when, I guess, you're trying to say, I want the court to intervene in this dispute. So coming to the summary, and we'll get to a few more of your questions and Mike's question. But realistically, all private business who have at least more than one owner should be thinking about having some sort of shareholders agreement in place. Unfortunately, people often think of these things when disputes start to happen, which makes it harder to get agreement on what should be involved, what should be put into a shareholders agreement. If you're thinking about bringing in a new shareholder in your company or a new unit holder in a unit trust, that is the time when you need to be putting in place the rules for when that business partnership breaks up. Unfortunately, we don't like to think about those aspects, But oftentimes when we think of them, it's a bit too late. Disputes often stem from money disputes or power imbalances. So where you have a majority owner who may have been the sole owner, started the business. They bring in a new shareholder at 20% who gets a seat on the board. The majority owner continues to act as if they are a sole director. That power imbalance causes dispute. So having a set of rules that everyone follows, now if they don't follow, that's another aspect, and that does lead to dispute. But at least we have a process in place for how that dispute can unfold. As we saw from our oppression case, the mountain is high for shareholders who want to bring actions in court, and costly. So having a good, clear understanding of how we resolve disputes, how the company will be managed and dealt with, how dividends might be paid, what the salary might be if you went that far into an agreement, those will help avoid disputes. So I guess the final point before we take some questions is that no matter the size of your business, a shareholders agreement is a must. So Adrian, I'll pass back to you.
Thanks, Paul. Before we get to the questions, and we will hang on the line until all of the questions are answered, so just so everybody knows, if you need to leave, feel free to do so. In terms of just a reminder, following the presentation today, you will receive a feedback email, or an email with a feedback survey attached. If you didn't get the opportunity to download the slideshow, it'll also be attached to that email as well, so you'll have the opportunity to do that. Please take the time to complete the feedback. We don't have many questions on there, but one of the questions on there is what topics you would like presented in the future. This topic and our last webinar last year were based on people requesting them. So we do take that on board. We will be running another webinar at the end of next month. And obviously we haven't set a topic yet. So if there's particular topics you'd like, please complete that. The recording will also be made available on our website. If you would like to watch it later or send it to somebody else to watch, feel free to. Now I'm going to return to the questions, and there are some good ones in there. So Paul's got his work cut out for him. Questions I'll notice. First one from Mike. I have a client of 3 siblings that all work in the business. The entity is a discretionary trust with corporate trustee. All 3 are equal shareholders, appointers, and beneficiaries. One of the siblings, who is also a director, is unreliable, and the other 2 siblings feel that his performance, or lack of, sounds like my family, is detrimental to the business. The 2 siblings have offered to buy the director out. However, he feels that he is part owner of a business and he should be able to work as little or as much as he wishes. That sounds like some business owners I know. He doesn't see a problem with his performance. What would you recommend as their next step, and what might their options be given one party doesn't see an issue?
Family counselling. I'm a bit glib there, but unfortunately, they really are family issues more than legal issues. The difficulty is that party is in an, I guess, in an equal sense, has equal holding of that whole enterprise, whether it be the company, the shareholder, trustee, or the trust. There's no real way to force them out. I guess at a director level, they could force him out, because 2 against 3, you've got 66% ownership, so you could force them out as a director. That's probably the only step out. Would be 2 of them, would be able to vote out at probably the company level, and you'd have to start at the trust level. So the shareholders in the trustee company, 66% would likely be able to get rid of a director at the trustee company level, and then that shareholder would be able to in turn do it at the next level. But from a family perspective, that obviously is lighting a fire. That may be what they ultimately choose to do. But ultimately buying them out is really going to be a matter of whether they're prepared to have that long-term dispute with that brother by forcing him out in that manner. Adrian, did you have any more?
Yeah, thanks, Paul. I'd probably say, Mike, I'd like to have a look at a copy of the trust deed just to see exactly powers of the appointers, for example, and how decisions are made, whether it's majority or unanimous. I mean, you're in a, as Paul says, it's going to be a dispute, I would think, no matter what you do. I mean, one thing you might look to try to do is move the business out of that trust into another entity that the other two siblings are. Of course, in doing that, you've got to have a look at what are the powers to do so. But I think the first step would be to read the trust deed to really drill down on what they can and can't do, and then let them know what their options are. Next question, Paul, is from Mark. A company is selling 3 times 10% shares. So I think it's selling 10% 3 times. In existing business, effective from the 1st of April. Company and 2 exiting shareholders the company has 3.4 million in retained earnings. How is it best to structure the shares so as to isolate previous retained earnings to original shareholders, and new shareholders only have access to dividends from profits from the 1st of April? I will say, Mark, if 2 are exiting, then I'm assuming they're not going to hold shares at that stage. So you've really got to clear the retained profits out before that. But Paul will come back with some comments in terms of other ways of structuring it to retain the access to it.
Yeah, I mean, I think you'd have to look at, firstly, are the shareholders' trusts. The only way to get those retained earnings out is obviously through a dividend. Are the shareholders' trusts, and therefore you could pay a dividend through to separate bucket companies, for want of a better term. You may have issues with having to pay extra tax in terms of, although if they own a third each, then they may not if they own more than 10%. If they didn't own their shares in trusts, it can be a bit more difficult. You may be able to look at some form of dividend access share or discretionary dividend share, but we'd need to look at, I guess, the circumstances a bit more closely.
Thanks, Paul. Another thing I have seen or done in the past, in that scenario, not where they've actually exited, but would be via the shareholders agreement. Obviously have some clauses in there to say that these retained profits are in essence belong, so to speak, to these shareholders, which also would require you to obviously need to update your balance sheets. And I have seen the scenario there where you've got 2 separate entries for retained profits pre 1 April, retained profits post, to try and get that differentiation there. Next question from a different Mark. Paul, do you have a standard shareholder agreement for a set price? If it needs to be tweaked, how does the cost work?
Yeah, we obviously do have a base precedent that we use and modify it for various clients. Price, we don't have a standard price per se. It will depend on how many parties are involved, because ultimately, in large measure, it will depend on how much agreement or disagreement there is amongst the parties to get everyone onto the same page. I generally say a draft of that agreement will be, depending on the business and the business type and the work that we have to do in analysing the business, will be anywhere between $2,000 and $3,000, and then from there, if there's significant negotiation, we'll rescope it at that point.
Thanks, Paul. And the questions keep coming in. Mike sent in some clarification on that. Mark has, and Mike. Mark, in terms of that previous question on the retained profits, Mark, what I'll do is I'll contact you separately to further chat about that. Question from Steve. Paul, is there a risk for advisors who do not recommend a shareholders agreement, particularly where shareholders are unrelated parties?
Yeah, look, I mean, I think accountants, I know plenty of accountants who have the checklists that are given out by their bodies that that say, you've got to cover off have they got wills and all those types of things. If you're a business advisor more than a straight accountant, perhaps I don't think there really is liability attaching to you not recommending one. I think it's just a good service that you have to provide. Obviously, it will come down to what your scope of your engagement is. If that's something that is in your engagement scope, or could be, then perhaps some sort of negligence might be levelled at you at some point. Again, I don't think it would have great legs to attach to you unless your scope of works was that narrow.
Thanks, Paul. Another Mark. Mark's a popular name today. Do you see shareholders' agreements being updated regularly?
No, they should be, and it's something that we will often do is contact previous clients who've had them probably. I've got a rolling rotation of sort of 3 years is when I reach out and say to people, hey, we did this 3 years ago. Does your circumstance look the same? Some clients are better than others, but generally the answer is no. Often they put in place an agreement, set and forget. They'll sell shares, they'll bring in new shareholders, and then suddenly someone will go, I didn't know there was a shareholders agreement. The new shareholders won't be parties to it, and that's when I guess a little bit of fear comes in, because they then start to think, well, what problems come from that? That is something we generally follow up with, but unfortunately, people do tend to set and forget, which they shouldn't do.
Thanks, Paul. My apologies if I mispronounce your name, but question from Arumagam. Why is lawful termination of employed directors' contract oppressive conduct?
Again, I tried to caveat that it's easy to put that as, I guess, a particular oppressive conduct. It does depend heavily on the circumstances. It may have been that within their contract, there may have been a particular clause that said that their employment could be terminated for a particular reason. It may have even been that the directors had sole ability to terminate without cause. In those circumstances, it would have been done for the purpose of oppressing that minority shareholder, rather than, say, for example, full cause for fraud or some other, OH&S type incident. I'm not aware of the circumstances of that particular case, but that was a circumstance in which the court found oppressive conduct. I would, I guess, as a general statement, I would say that lawful termination is generally not going to be oppressive conduct without more.
Yeah. Thanks, Paul. Question from Robert. Where you have a holding company with 100% owned subsidiaries, can you have one agreement to cover all of the companies?
Yes, and you probably should. It would be one, well, not probably should, you should. It would be one all-inclusive, and bind each of those separately. Bind them each separately to all of the shareholders as well.
Okay, thanks, Paul. Just a couple to go. One from Melanie. What generally happens when there are two shareholders? They applied for TPD life insurance as a buyout option. However, one was denied. Is there best practice for a fair outcome for both?
Yeah, there is. So it depends on what the denial, what the denial is about. Sometimes you may be able to, self-insure in some way, that rather than the company pay premiums to the insurance company, they may pay it separately to a bank account, which accumulates over time. That may not always work. It really is a question for how the directors want to approach that. If the denial is down the road, they got coverage, but the payout was denied. There needs to be some consideration of, well, why was payout denied? Was that because of a failure to disclose? In those circumstances, they need to consider whether that director should be penalised for that or not. So yeah, they're things that you need to think about and consider with the client.
Thanks, Paul. And last one is a comment from Brad on the 3 times 10% share example, saying, wouldn't the value for which these shares were sold, particularly if I was an existing shareholder who was selling out, I would want the price to include the retained earnings on the price. That's true. I'm assuming, and I don't necessarily want to comment from Mark on this, is I'm assuming that they're not taking it into account because that will increase the sale price and increase the taxing event, and they prefer to keep it in the company and access it at a later time. Thank you for all those questions and for all of those that stayed in the room while we went through them. As I mentioned, both Mark and Mike will reach out to you separately about your queries because there's a fair bit more to delve into there. Just a final reminder about the feedback emails. If you could complete those when you get them, it's much appreciated. Thank you for coming today, and thank you for your time, and hopefully we'll see you again in another month.
Thank you.